Good morning. As I said, I'm David White. I'm a public interest environmental lawyer. I've worked for a lot of environmental organizations and in public interest private practice. And I'm happy to be here today. Right now, I'm working for the National Wildlife Federation as their Gulf of Mexico Restoration Campaign Director. I have been a litigator for the National Wildlife Federation. I've worked with Ocean Conservancy on marine issues in the Gulf of Mexico. So all of that is near and dear to my heart. Unlike some of the previous speakers, I am happy to speculate, surmise, pass gossip and rumors. So if you have any questions, I'm happy to try to respond to all of them. And if I don't know the answer, I'll make something up because I'm a lawyer, I can do that. I also should tell you right up front that I'm a recovering PowerPoint user. And I'm trying to wean myself off. I'm in the 12-step program, and I'm not going to be using them, although I might be jonesing for some of Teresa and Jordan's slides later on, so you AV people pay attention, because I might be calling them up. I'm going to be here talking primarily about the Florida parts of the RESTORE Act, and but before I do that, I want to make some observations about the RESTORE Act. First thing is that it is one of the most poorly written laws that I've ever seen. And the reason that there's so many questions is because it leaves so many questions open. There are undefined terms, there are conflicting provisions. It's extremely complicated, and I've read this thing, I've studied this thing at least a dozen times, and every time I read it, I come across another inconsistency or contradiction somewhere in the law. And so, you know, that's the bad news. The good news is that because it is so ambiguous, you know, we can make up stuff. And we can, through advocacy and by people getting engaged and people asserting their rights, we can get a good outcome out of this process. The other thing I'd like to say is, you know, I hear a lot, especially from our brothers and sisters in other states, about, you know, this is about restoring the economy as much as it is about restoring the natural resources of the Gulf of Mexico. And I don't think that's the case, because we worked on the RESTORE Act on a national basis. The National Wildlife Federation has affiliates in most of the other states. We've worked very closely with other national NGOs, Audubon, and a lot of the sportsmen's groups. And we didn't do this to get a stimulus package that only benefits 5 states. We did this because we convinced Congress, we convinced those legislators from the other 45 states that this was an opportunity to fix some of the insults and some of the damage to the Gulf of Mexico that have occurred over the last 50 years of oil and gas development, of port construction, of canals and dredging and water quality violations and a lot of the other insults, the dead zone, the things that happen in other parts of the country. And that's why Congress passed the RESTORE Act, because, you know, as Teresa and Jordan said, there are 2 other sources of compensatory funds that BP and the other responsible parties are totally on the hook for paying. The economic damages. Anybody, any local government, any entity that can show any economic damages, and believe me, we've seen some really interesting ones, can get compensated by BP, and BP is being very generous in that regard. The Tampa International Airport has a claim for $1.4 million because people who were coming from Europe for vacation heard oil on the beaches in Florida, and they didn't look at a map. So they didn't get rental car commissions, and they didn't sell, you know, cheeseburgers in their airport. They have a claim for $1.4 million, and they'll get paid. I heard that Ritz-Carlton in Naples got a $4 million claim because they could show their occupancy over time, and then boom, April 2010, it fell off. So for economic damages of any sort, color, frame, you should be getting compensated for, and there's no shortage of lawyers out there, trust me, that will take your claim for no money up front and get you a check. And so all economic damages from local governments, bed taxes, sales taxes, any conceivable economic damages should be covered under the economic claims that BP has set up. The natural resource damage assessment. all natural resource damages, from seagrass, from dunes being trampled, from the seagrass being churned up while they were putting booms out, from the loss of fisheries, to the extent that you can prove that up, to the floating mats of sargassum out in the Gulf of Mexico that had baby sea turtles and juvenile bluefin tuna in them, and also because of the eddy that created the sargassum mat, got oil in it, and they just set it on fire to get rid of it. Well, how do you put a dollar value on that, not only in terms of sea turtles, bluefin tuna, but habitat? How do you put habitat value? So this natural resource damage assessment process is going to be going on for a very, very long time. And there needs to be payments along the way, like the early NRDA restoration, but we shouldn't wait to get all of the information. Now, what's likely to happen is that at some point, now I heard this, and this is speculation, that so far there's been 70 million pages of documents filed in the multi-district litigation. So nobody wants to go to trial on this, so they might end up settling 80 cents on the dollar, 90 cents on the dollar, 60 cents on the dollar. So a lot of those other claims will fall out to try to get money going into restoration projects and to get people paid. So those two sources of funds, I don't want to call them pots because that'll confuse us with restore, but those two other sources of funds are compensatory in nature. And the Restore Act is not. The Restore Act is punitive in nature, and this money should have gone into the federal treasury, and we, the conservationists of every stripe, local congressional delegation from the 5 Gulf states, convinced the other 45 states in a very contentious Congress, if you haven't been paying attention, in a very tight time for financial situation that this country is in, convinced those other 45 states to send the money back to the Gulf of Mexico because they recognize it as an American treasure. They value the seafood industry. They value the estuaries. They value the tourism. They value the culture of the Gulf of Mexico and the seafood, and people who come here that want to know that their seafood is both safe and sustainable. And that's why they did it, not as a stimulus package that only benefits 5 states from recovering from the economic recession that all the country is in. And so the point of that is that the 5 Gulf states and the citizens and the elected officials of those Gulf states have a responsibility and are accountable to the rest of the country for how they spent that money. And we should spend it on restoring the Gulf of Mexico. And we can do that and at the same time stimulate the economy and create jobs. I reject categorically the notion that there's an environmental pot and a restoration pot. We should put this money into restoration, and in the process, if we're smart and clever and leverage the money and use it carefully, we can stimulate the local economy and restore the Gulf of Mexico. And those projects that do not have a nexus to Gulf restoration, like civic centers or highway projects, should have a higher burden, I would argue, because they don't have the same synergistic effect as restoration projects that do have a linkage to the Gulf of Mexico. Now, the National Wildlife Federation has chosen estuaries as a focal point of our campaign to restore the Gulf of Mexico because that's where the fish come from. And estuaries lets us cover a lot of ground in terms of habitat protection, in terms of fisheries, in terms of seafood production, in terms of jobs, in terms of we've already invested in these special places. That's why they're national estuaries, because we've recognized them as drivers of fisheries and economics of the Gulf Coast Council. Estuaries also allows us to get up into the watersheds to help in the terms of the parlance of the Everglades Restoration Project, getting the water right. You can't go out and put seagrass beds and oyster bars out there if the water is not right. And so the Restore Act is a ton of money, and it gives us the opportunity to look at an ecosystem scale on projects that we could only dream about in these tight fiscal budget years, getting the money for. And so we see the Restore Act as an opportunity to create a legacy for the Gulf Coast, to make their communities more resilient, both economically and ecologically, to help buffer us by restoring wetlands, by restoring oyster bars, and mangroves and seagrass beds. We can help our communities become more resilient to the storms that are coming. And finally, if we don't make good decisions on how this money is used, When the next oil spill happens, and we know that it will happen, then the Gulf states are going to want to do a Restore Act Part 2. And the first question that Congress will ask is, how did you spend the money last time? And to the extent we have not used it to restore the Gulf of Mexico, they're not going to be as interested in doing a stimulus package for the Gulf states that they don't get to participate in. And the environmental community may not be behind it in the way it was on this Restore Act. You know, it's people from the Montana Wildlife Federation and the New Hampshire Wildlife Federation that went to their congressional delegation and say, let's fix the Gulf of Mexico. Let's take this, because the beauty of it was, of course, that this money didn't come from tax dollars. It came out of a multinational corporation who makes huge profits pushing deeper and deeper into our oceans, taking the resources and making huge profits in the process. So it was really a once-in-a-lifetime opportunity that didn't come from taxpayers, but it did come out of the federal treasury, because this money would have gone into the federal treasury. And so it is, you know, to some extent a windfall to the 5 Gulf states, and it's a great opportunity for a legacy, and we ought to capitalize on that. Let me talk a little bit about the Florida-specific regulations, and well, let me before I do that, let me talk a little bit about Restore Act and how messed up it is. We talked about timeframes, and all of these things essentially have to happen simultaneously under totally unrealistic timeframes. In the Restore Act, the rules and regulations are being developed by the Treasury Department because they're controlling the money. They're taking it out of, once they get it, they're taking it out of federal treasury and sending it to the states, to the council. So they have to come up with the rules for how the states get to apply for this money, how the council gets to do this. Well, those rules are being drafted simultaneously with the council formation, council development. All these things are supposed to be happening at the same time. So I'm not sure how you can do all that when you don't really know what the rules are. So, you know, normally they would say, okay, the Treasury has 6 months to develop these rules after notice and public comment, and then the council shall use those rules to, you know, and it should happen concurrently. For example, the science component that Jordan talked about from the 4th or 5th pot of money. Well, the council is supposed to be using the information that they're generating to inform them on the comprehensive plan. Well, they don't have the money yet, so that's why they're not meeting, because they don't have the money yet. So all of this thing is supposed to be happening simultaneously, and it's totally unrealistic to think that that'll happen. And I just can't imagine that the council is going to meet their 6-month time frame for putting out their proposed plan. And so what they ought to do is they ought to tell people in their first meeting, okay, you know, we're moving this process back. We're starting the clock now from our first meeting. We have 6 months from now, and here's how we're going to proceed, rather than this arbitrary deadline of January 6th or whatever it turns out to be. Because right now, everyone is scrambling trying to figure out what's going on, and especially in the other states. And they're scrambling, in my judgment, over the wrong pot of money. The only real deadline is for the council allocation, because they have 6 months to do the proposed plan and 6 months to do the interim plan, and they're supposed to be including in that interim plan, which is a year from whenever the clock ultimately starts ticking, to come up with a list of projects that they're going to fund in the next 6 months, in the next 3 years. So that's where everyone should be focusing their attention, in my opinion, because that's where the time frame is. The state allocation, they could put that money in a trust fund and spend a year or 2 or 5 trying to figure out how to spend it. The third pot of money, these are pots that are funds that are allocated to the states or to the counties, depending on the state, and there's no time frame on how that money is spent. They could put it into an endowment and fund projects out of it, but they're not. They're scrambling and trying to figure out how to spend their source of funds when there's no time frame on that. And I'll tell you, there's going to be a lot of people in Alabama and Mississippi and Texas who all of a sudden realize that the council is going to spend a bunch of money potentially on doing storm diversions of the Mississippi River in Louisiana and Everglades restoration projects, and they're going to say, well, how come we're not getting any money? Well, you're not paying attention to the time frames, and I think they're going to be very surprised. So, okay, so let's talk about Florida. So the message is we need to be paying attention to the Treasury Regulations because they're the rules of the game. And they're important to Florida because all of the states, and in Florida, the counties, have to come up with a plan for how they're going to spend their state allocation, the first pot. The RESTORE Act doesn't say where that plan goes, but it will go to the Treasury Department. And so under rules that they haven't made yet. So we need to be paying close attention to the Treasury Department and sort of pushing them on making sure that these projects, these funds get spent on projects that restore the environment and stimulate the economy and not the other way around. So let's see. So let's talk about Florida. Now, in Florida, unlike the other states, the money comes to the counties. What counties? We don't really know. So the RESTORE Act says 75% of the money goes to the 8 disproportionately affected counties, but does not list them. We're assuming that we know what they are, that they're Escambia through Wakulla, but it doesn't say that. It just says 8 disproportionately affected counties. And then the rest of the other 25%, so there's the 75%ers and the 25%ers. So the 25% of the funds go to the non-disproportionately affected counties. And we don't know what those are. We're assuming that they're the 15 counties from Taylor County, I think it is, down to Monroe County. But we don't know that because the RESTORE Act doesn't say that. In fact, we're all assuming that it means the 15 coastal counties. But I read a legal analysis of the RESTORE Act last night that was done by the Tulane Law School that suggests that it's the other 59 counties divide the other 25%. We need to figure that out. And I don't agree with the Tulane analysis for reasons of legislative construction that we don't need to talk about. But if Tulane Law School thinks that it's all 59 counties, it's worth taking another look at. Is the point of that. Yeah, did you have a question? Well, the law says coastal political subdivisions. And it defines those as counties along the coast. But here's how vague the law is. It says in it at one point about distribution of these funds under the first pot of money, the state allocation, it says, in those states where the coastal zone includes the entire state, this is how it happens. Well, Florida's the only one. Why don't you just say Florida? In Florida. So it leaves people like so it's just really vague. So there is a provision that says that defines coastal political subdivisions as that level of government one step below state government that have borders contiguous to any portion of the Gulf of Mexico. But then when it actually does the distribution of 75-25, it doesn't say coastal political subdivision. It just says the 8 disproportionately affected counties, does not name them, and then says, in the non-disproportionately affected counties, they divided 20% up to 25% according to this weighted formula, but nowhere in it, it comes under the heading of coastal political subdivisions, which is why I don't think the Tulane analysis is correct, but somebody could argue that.
Okay, Jennifer, sorry. So you're saying in the federal language there isn't the definition of the disproportionately affected counties, but what about the definition that's in Florida statute? How does that interface?
I'm going to get to the Florida statute in a minute.
Okay, thanks.
So it all goes to, this is extremely vague, and we need to be paying attention. Otherwise, this could really blow up and be okay. Ralph?
David, one thing, Ralph Brooks, to keep in mind, too, is that in Florida you have tributaries like the Withlacoochee that go through inland counties. You have C-43 reservoir that benefits the Caloosahatchee, which is actually located in Hendry County, a non-coastal county. I know there's other pots of money, but if we're looking to restore Florida's estuaries, we want to keep an eye on upstream projects that can improve the downstream estuaries.
Yeah, so the RESTORE Act says that the money has to be spent within the Gulf Coast region, which is defined as essentially the floodplain, no, the coastal zone, the coastal zone, which is defined under the Coastal Zone Management Act. So all of Florida is within the coastal zone. So it says the money must be spent in the Gulf Coast region, which is the coastal zone plus 25 miles. So essentially, anywhere in Florida or 25 miles into Georgia or Alabama, Florida can spend that money. But the entity that defines where that money gets spent is either in Pot 1, it's these disproportionately and proportionally affected counties, and in Pot 3, it's the consortium, which I'll get to in a minute. But the money could be spent anywhere in Florida, so it could be spent somewhere else, in some other part of the state. Okay, so the non-disproportionate counties divide up 25%, and I'm assuming, let's assume for the sake of argument, that it is the 15 Gulf coastal counties. The Treasury will ultimately decide that. Again, that could be decided in the Treasury Regulations. What do you mean by that? So as Jordan and I think Teresa talked about, there are eligible activities, and it must be one of those eligible activities, which are fairly broad, but clearly, 90% of those eligible activities are related to Gulf Coast restoration. So you can pick 2 words out of that says, job creation, and I would argue that it's just as consistent with the statute that job creation has to be coordinated with environmental restoration. You don't have to do one or the other. We can do both, and if we're smart about this, we can do both. So let's, I'm sure there's other questions about this, but let me talk about the consortium a little bit. Or let me talk about state law first, because that's another, maybe even more poorly worded than the Restore Act, so it's worth talking about. Okay, so in the 2011 legislature, State Senator Don Gates introduced this bill, essentially the Oil Spill Restoration Act. And what they tried to do in that statute is they tried to, in my opinion, is they tried to funnel all of the money into restoration, into economic restoration. So the state law does, in fact, define the 8 disproportionately affected counties as basically the 8 panhandle counties. Everybody knows what they are. But it says in it, and this was before the Restore Act was even introduced, so they were making this up. What it says is any funds received by the state from any governmental or private entity for damages caused by the Deepwater Horizon oil spill shall be deposited in the applicable state trust funds and expended pursuant to state law or as approved by the Legislative Budget Committee. Okay, so I would argue that none of the state allocation meets that definition. Because number one, it's not damages. That's why it's so important that we look at those 2 compensatory sources of funds, the economic damages and the NRDA process. Those are damages. The Restore Act is not damages. This is money given by Congress to restore the Gulf of Mexico and the economy of the Gulf states. The second thing is because it goes directly to the counties, it is not being received by the state. So I would argue that the state law is inconsistent with the federal law. So what the state law says is that 75% of the money may be used on scientific research into the impact of the oil spill, on fisheries and coastal wildlife, and environmental restoration of coastal areas damaged by the oil spill in any disproportionately affected county. Well, that's what NRDA does. NRDA should pay for all of that. It should pay to look at the impacts of the oil spill on the resources, and it should pay for the restoration. So if we do NRDA right, none of this money under the statute would go to restoration. It would go to the other 2 allowable uses of this funds, which is economic incentives directed to any disproportionately affected county, or initiatives to expand and diversify the economies of any disproportionately affected counties. Because the other 2 environmental things should be covered fully under NRDA, and that leaves the economics. On the 25%, the 25 percenters, the remaining 25% of monies may be used for scientific research into the impact of the oil spill if they're non-disproportionately affected counties, they didn't have any impact, environmental impact from the oil spills, and if they did, it would be covered under NRDA. But it's along any of the state's shoreline. So I presume that means from Pensacola to Fernandina, because it says any of the state's shoreline, and that is not a disproportionately affected county. And environmental restoration of coastal areas damaged by the oil spill in any county other than a disproportionately affected county. That means the other 59 counties. How were they affected by the oil spill? And if they were, that would be NRDA. Or the alternative is economic incentives directed to any county other than, so the other 59 counties, or incentives to expand and diversify the economies of any county in the state, which is also the 59 counties. So again, there's no help in figuring out what this is all about. And then they say the Department of Environmental Protection is the lead agency for expending the funds directed for environmental restoration, which under my opinion would be zero. And then the Department of Environmental Economic Opportunity is the lead for the rest of the money, which according to my analysis is all of it. So, so that's basically the state law, and I would argue that the state law is void. It does not apply, at least to the first state allocation, the first pot of money. It would apply potentially to the third pot of money, because the third pot of money, as you heard, would be according to a plan put together by the consortium, but then that money but the governor or his designee would have to take that to the council and get that approved, and then the money would then go to the state, but it would go to the state in accordance with the plan put together by the consortium. Jennifer?
Jennifer Hecker. I was following all of that, but there's only one thing that I'm not getting. For the disproportionately affected counties, it makes sense that, as you're saying, that restoration associated with damages should be paid through NRDA. But when you go down to the second half that talks about what should be done with the remaining 25% with the non-proportionately, with the non-affected counties or less affected counties or whatever.
Non-disproportionately affected counties.
There you go. That's a long way of saying it. But NRDA doesn't include those in its scope. You know, it's really limited to those 8 counties. So I understand that it seems that here there is something to address restoration, albeit associated with damages, which would be very hard to prove for those counties outside of the Panhandle. But at least there is something here, whereas in to say, well, NRDA should take care of that, NRDA doesn't include those non-affected counties in its scope. So how do we cover the gap there with the counties that are outside the Panhandle?
Well, you could if, for example, the argument about the fish not coming back, because we grow them here, we send them out into the deep sea, they're affected by the oil spill, and they don't come back. So if you could prove that up, then you would have a claim for that. The question is, could you prove, and the standard would be, could you prove in a court of law with a preponderance of evidence that in fact happened? And then if you could prove that, then what would the remedy be? And you would have to come up with some sort of dollar figure that would be, reasonably associated with that. So that's a way to get to NRDA from here, say.
Well, that shows the damages, but it says that you have to also show that the coastal area was damaged by the oil spill. So you would have to link that those fish weren't coming back because of the oil spill.
Right, there has to be,
which would be a very difficult.
Everybody agrees that for NRDA, there has to be a nexus to impacts from the oil spill.
Okay.
Anybody?
Mick Denham from the city of Sanibel. I think I've got this clear, but I'm still just a little confused. NRDA is clearly associated with the oil spill from BP, and I understand that. The Restoration Act can be for any restoration activity. So if, for example, the oysters on the Gulf estuary of Caloosahatchee had disappeared for whatever reasons, but clearly because of a variety of issues in the Gulf over the last 50 years, that indeed could be part of the Restore Act. Is that correct?
Yes, correct.
Okay, so the Restore Act, the City of Sanibel, for example, could work through Lee County, justify that as being a reasonable restoration, and working with the county that could find its way and be covered by the Restore Act. Am I got that correct?
It could be covered under any of the three pots.
But it can't be covered by the
It can't be. For
No.
NRDA, there has to be
Correct.
a direct nexus to the oil spill.
But in terms of the estuary, we could cover that
Correct.
via Restore. Okay, thank
Under
you.
any of the three pots.
Yeah, and one further question. You know, I came here this morning assuming that there was nothing in it for the City of Sanibel, but I'm now believe that there maybe is. So,
Wait until you hear about the consortium.
say that again.
Wait until you hear about the consortium.
So I'm pleased about that. But if I want to direct my attorney to where he should go look for information, is it the Act itself, or is there other? Maybe you can give it to me after this meeting. But should I direct him to get all the appropriate information? That would be useful information.
You know, you could direct them to me, you could direct them to Bethany, the Ocean Conservancy, the National Wildlife Federation, Audubon Society. We're all in this game.
Okay, got it.
Because we have, you know, the national groups especially, and the Conservancy of Southwest Florida on a local basis. Again, you know, we're advocates, and we're advocating for this money to be spent on restoration. The bigger the scale, the better we like it. And if it's, you know, and that's why we're focusing on estuaries, and we should be focusing on national estuaries because we've already identified those as special places. We've already got skin in this game. You've all put a ton of work into finding out what the problems are and what the solutions are, and how are we going to, you know, come up with a plan and a wish list of, if we only had the money, this is what, you know, prioritize it. The local governments from this area that surround and are participants in the Charlotte Harbor National Estuary could decide under the state allocation to take your percentage, your portion of the 25%, or some part of that, form your own consortium, and submit your estuary plan to the Treasury as your plan, because every county in Florida has to come up with a plan that it submits to the Treasury for how they're going to spend the money, and the Treasury Department will decide whether that comports with the requirements of the Restore Act.
But help me here again. So, but if the Charlotte Harbor National Estuary Program wanted to come up with an issue which they felt was a restoration, they would then in turn have to go through a county to apply for that. Is that correct?
Correct. It would have to be through the county for the first pot. For the state allocation, because that money goes to the counties. So the county could come up with its own plan on how they're going to spend the money, send that to Treasury, or it could combine with other counties and put all or some portion of its funds towards the estuary plan.
I think I understand. Thanks.
Sorry, I just have one follow-up question. So you, going through this Florida statute, state law language, have been arguing that it doesn't really apply to the Restore Act funding. What about trying to amend the statute to address the fact that basically it's not including environmental restoration for non-oil spill damaged Gulf coastal counties? I mean, there's nowhere in this statutory language that there's an avenue for that. Instead of arguing it and risking that someone's not going to accept that interpretation, is there a way that we should be spearheading some effort to amend this, to include that?
I would be shocked if the legislature didn't come back. Now remember, Senator Don Gates was the one who drafted this. He, for the next 2 years, will be the president of the Senate. So I will be shocked if they don't come back in the next legislative session and do a glitch bill to try to fix this in a way that gives the state more control and does not run afoul of the language in the Restore Act, which would kind of be hard to do because it's extremely vague. The only thing in the state law that really has any effect, in my view, is that it's the only place where the 8 disproportionately affected counties are actually defined.
Jason Stosfus again with Charlotte County, and we really appreciate this information. It's great. I know you're going to talk more about the consortium, but you mentioned one thing that I just wanted to make sure that I understand clearly. again, a lot of the information that we've been receiving at the county level has been from FAC and as they're working to develop that consortium. And I think the commissioners from the 23 counties are kind of under the impression that the consortium will not only develop a plan, but determine how to administer and allocate the state pot of funding. And from what I understand from what you said and from what I've read, really the only thing that the federal law states is that the consortium will be responsible for developing the state's plan. It doesn't implicitly state that the consortium will then allocate the funds to the various counties or decide how to allocate those funds. Is my understanding of that correct?
The consortium the only authority the consortium would have is to come up with a plan for the third pot of money, the oil spill impact allocation. Now, they have offered the 23 counties at their discretion technical assistance to help, because every county under the state allocation has to come up with a plan. And so they have offered technical assistance with those plans if they want it, if they desire it, but they have no authority to dictate any decision-making or allocation under the state allocation, the first pot.
So when the consortium develops a plan, that plan would talk about the types of projects that would be eligible and criteria, et cetera, but that plan would not necessarily include a formula or a method to allocate the funds to the various counties within the state.
It could, under the third pot.
Right.
Right, it
Okay.
could.
Okay.
It just says come up with a plan. So let me talk about the consortium, because I'm sure a lot of people are interested in that. So the RESTORE Act says that for the third pot of money, so this is money that the states will get, but it has to be approved by the council. It has to be consistent with the comprehensive plan, and the act gives the chair of the council basically a veto over that state plan. And I'm not saying this is likely to happen, but it's possible to happen. And the council and a state representative, and it doesn't have to be the state representative of the state that put the plan on the table, can approve it, even over the objections of the other 4 states and the other 5, 6 agencies. So the chair has enormous power, and so the consortium. So in the RESTORE Act, it says that the plan shall be put together by the state. And in Texas, it's the governor's office. In Alabama, it's the Alabama Coastal Council. In Florida, it's the consortium. And it says, I don't have it in front of me, but it says that the consortium shall put together the plan. The consortium shall be made up of local political subdivisions and must include at least one representative of each county. It doesn't say county governments, it doesn't say counties, it just says local political subdivisions. Now, the RESTORE Act defines coastal political subdivisions, but local political subdivisions is not defined. It only appears in one place in the entire statute, and it's talking about the Florida Consortium. It doesn't say that the representative of the and it also says it must include one representative of every affected county. It doesn't define affected county. And so what happened is the Florida Association of Counties stepped into that vacuum and said, we'll put together a consortium, and essentially put together this consortium agreement made up of the 23 disproportionately affected and non-disproportionately affected counties, and have come up with bylaws and an opt-in process where you have to accept the articles of incorporation to get into the club, and your county commission has to approve it by resolution and record it, and it has the rules and regulations of it. Now, every county, every one of those 23 counties, according to this system that the Florida Association of Counties has put together, every county is guaranteed a seat at the table and a vote at the table. Now, they have said that they will also entertain the notion of including other political subdivisions like municipalities, but you have to be voted in. You don't automatically get in, and you don't necessarily get the same voting rights as a county representative. And the reason that this is so is because they say it's so. They're making this up. There's no regulations, and that's what happens when you get a bunch of lawyers in the room. They make stuff up. But there's nothing to stop, for example, the governor by executive order by saying, you're not the consortium. I'm creating the consortium, and here's who's going to be on it. There's nothing to stop the Florida League of Cities from developing a consortium, that as long as it's consistent with those guidelines in the Restore Act, which is the consortium shall be made up of local political subdivisions with at least one representative from each affected county. We don't even know for sure what it means by affected county yet. It could be the 23, it could be the 59, and we're making it up as we go along. All I'm saying is, and I think from my perspective in the environmental community, we're probably better off with the system as it exists now that the Florida Association of Counties has put together, because could you imagine a consortium of 67 representatives if affected counties means all of them? I mean, that would just be unworkable and unmanageable. Is anybody here, raise your hand if you want Miami-Dade to be part of the consortium, or Duval, or Orange County. So I'm not trying to throw a monkey wrench in this, and we might be better off. I think we probably are better off with the way it is now. I'm just saying they're making this up. Jennifer.
So the consortium already had its initial kind of gathering in St. Pete. I wondered if you had attended, if you had any insights to share from what you observed in that first meeting.
Yeah, so there were 3 meetings so far. There was one in Pensacola, I think, or Destin, and one in Panama City, and one in St. Petersburg on the 19th of September. And I was not at that one because I had to be in Washington for a different meeting. But essentially, the first meeting is that they did the same presentation as you saw here. This is the Restore Act. This is what it means. This is how it relates to NRDA and Clean Water Act. And it was just an informative meeting, and very few people showed up. Very few county. They asked a representative of each county and a staff person, resource staff person, to show up. Very few showed up. The second meeting was in Escambia, in Panama City, and they said, you really need to come. We're putting together this consortium. You need to be there. And 4 counties did not show up, including Pinellas and Hillsborough, who will probably take the most under this 25% allocation because of their population, their distance to the Deepwater Horizon, as the seagull flies, and they didn't show up. And so the third meeting in St. Petersburg, they all showed up, and they were just sort of deciding about what to do about this, about the consortium. Now, it's very clear that the 8 disproportionately affected counties in the Panhandle have been paying attention to this all along. They're very savvy. They know exactly what's going on. They're plugged in politically. They've hired lobbyists to get the Restore Act passed. They're counting their money long before they ever thought they'd get it. The other 15 counties, not so much. And they're trying to figure out, in the same way we all are, what this means to them and how this is going to play out in their counties. How am I doing on time?
Oh, you're about running out. That's our last question, and your final
Everybody
words.
happy? Ralph? Yep. I don't know. All these people show up in a room. We're sitting in the audience. They introduce themselves, but I mean, it's like drinking out of a fire hose. There's all of these people there. And I don't know. But if you go on the Florida Association of Counties website and put in their search engine, Restore Act, you will get the minutes of these meetings, the attendance list, the PowerPoint presentation, all of the documents, the consortium agreement, the draft resolution that the counties have to have to get passed. All of that is on the Florida Association of Counties website.
Thank you very much. Pete Quashis from the Snook Foundation in Audubon. As you know, we've been beating the drum for C-43.
Correct.
And how do we work a SERP project, essentially with the support of the Water Management District, with the affected counties, which has a huge nexus for Gulf fisheries and long-term restoration, but it's a $700 million project. How do we fit that into the system?
Okay, so That's an excellent question, and that's the kind of ecosystem scale project that we would, that we were supporting. So let's just say, everybody's talking about nobody knows how much money is going to come in, but just let's say, for the sake of argument, it's $10 billion. Say $10 billion shows up in the trust fund. Okay, so Florida, under Pot 1, would get $700 million of that, 7%, correct? So Florida's going to get, but that's divided up. You'd have to convince Escambia County to spend it on, good luck with that. So one of the benefits of the RESTORE Act is this money, although it's technically federal money, it can be used as a match against other federal money. So it could be used in that way, as a state share. The second pot of money, the council allocation, would be $2.4 billion. That can be spent without regard to geographical jurisdiction. So they could spend half of it in Louisiana restoring marshes and half of it in Florida restoring the Everglades. Now, politically, I don't think that would be very difficult. However, to the extent, I would make this argument, to the extent that the states are spending their money under the discretionary pot, Pot 1, on things other than restoration, they shouldn't be heard to complain about big ecosystem scale restoration projects taking up the lion's share of the second or third pots, because they had the discretion to spend it on restoration, and if they don't, they're saying it's not a big priority for us. So, there's that. The third pot of money, the consortium could say, okay, we're going to look at the big estuaries. We're going to look at Apalachicola. We're going to look at, Florida Bay and do the Tamiami Trail Bridging Project. We're going to look at Charlotte Harbor and do the C-43. We're going to look at the Tampa Bay Estuary Program and meet their goal of replanting 40,000 acres of seagrass once we get the water right. So that's what we would be looking at from the consortium, is big ecosystem scale. Now, you're right, is the consortium could say, we're going to divide up the money in the same way we divided up 75% to the eight disproportionately counties, and everybody else can fight over the scraps. And if that happens, shame on us. We should be looking. The second and third pots of money are designed, and correct me if I'm wrong about this, to be competitive projects that primarily favor ecological restoration. And so all of these projects should be put into a competitive process where the best projects, the ones that are most shovel-ready, and that would be the Everglades projects, they've already bought the land, they've got engineering plans, they've got an engineer's report, they're just waiting for the money. That is about as shovel-ready as any project that I've seen in the Gulf of Mexico, with the exception of the water diversions of the state master plan in Louisiana. That ranks it very high under the second pot of money. If you look, now I wish I had the slide. See, I'm jonesing for the slide. But the second pot of money has priorities, and the Everglades projects meet every one of those priorities in terms of shovel-ready, ecosystem scale, big impacts. So, so the second pot of money and also the third pot of money would be somewhere in the neighborhood of $2.4 billion divided upon a weighted formula. It depends, we'll see how much Florida gets. Florida may get a lot. Here's where we go back to the Treasury regulations. The third pot of money is divided on this weighted formula according to how many miles of shoreline got oiled, is one of the criteria. If Louisiana starts looking at nooks and crannies in numbers of miles of shoreline, they're going to take the lion's share of the money, because Florida got very little oil, and what it did get was mostly linear on beaches. If Louisiana starts counting nooks and crannies and all those bayous and tributaries and inflows, they're going to take the lion's share under that weighted formula. Who decides that? The Treasury. So we need to pay attention to this. Thank you very much.